Hi, I'm immigration lawyer John Kasravi. Thank you for joining our show, Immigration Talk, today. We're going to go over some important topics in immigration, in particular, immigration categories that are having huge backlogs and issues. So the topic is forget these immigration options in 2023 because they're so delayed that may get pushed back after this year if you have one of these cases. We're going to talk about why the reason is, and on each topic, both different family-based and employment-based categories, including the diversity visa lottery, things you could do or to ameliorate or lessen the consequences or other options that are possible. I'm here with my associate Anya Sergeyeva. Anya, good to see you.
Hi, John. How are you doing?
I'm doing good. I wish we didn't have to do this conversation because it doesn't help our clients. It doesn't help those trying to immigrate to the United States. But it's better to have a realistic understanding of what's going on, so you're kind of aware. You're not just waiting on something that's taking forever. And that's what we're seeing today when it comes to the family categories, in particular, brothers and sister cases, and including adult children. But let's just jump into it on there. The thing that's been hitting really hard is a slow movement in family preference categories. So you talk about what preference categories are and particularly how they're affected.
So, preference categories, for those who don't know, there is such a thing. It's called visa bulletin. It contains all the preference categories, starting from like adult children of U.S. citizens and ending with brothers and sisters of U.S. citizens. So basically, there are four categories, actually like five. Okay, and we're gonna start with the F4, brothers and sisters of U.S. citizens. This category is hugely backlogged. Okay, it takes years and years, and if you look at the visa bulletin currently, you might think, okay, maybe it's going to take like 15, 20 years for my category, for me to immigrate and finally, get reunited with my brother or sister. But actually, visa bulletin does not show the real numbers. What I'm talking about, it does not allot for the cases that are in the backlog in this particular category. So, for example, if you file in your case in 2007, yeah, you might be able to immigrate right now under this category. But if your case was filed like 2015, for example, if you look at it, okay, it's maybe 7 years from the visa bulletin current priority date, it might necessarily be the case. So why is that? There is a limit in this particular category, like 65,000 visas that can be issued every year, and every family member counts. Okay, so there are some sources. There is not much information out there available how the big backlog is in this particular category, but some sources suggest that there are around like 3 million cases for all of them, and around 2 million cases for those who are not from Mexico, not from Philippines, and not from India and China. Okay, and if you take this 2 million cases of backlog, right, divided by 65, and you can get like some crazy number of years that potentially you may need to wait before you can get your green card. Okay,
Yeah.
and is it worth filing right now in F4 category? Probably it's still worth it, because if any sort of legislation change would happen, potentially you may use this pending or filed petition for some other purposes. Like they were talking about, like, I don't know, like V visa, for example, in one of the previous legislation proposals, where, for example, if you have, say, some immigration petition pending, and you can come join your family in the US and wait for your visa number here in the United States. Again, this is just a proposal. We don't know if it's going to happen. We don't know when it's going to happen. But answering the question, is it still worth to file it? I think it's still worth to file it. But again, don't think that you will use this particular F4 visa anytime soon, because the backlog is huge.
And there's an importance in it for filing for a family members where you do a brother or sister and you have nieces and nephews. So the sooner you file it and get that case in, that helps out for hopefully the child stays under the age of 21 or close to it, so they can be part of their parents' petition when the time comes. So for the nieces and nephews, it becomes really important. If you're thinking about this, if you have citizenship, because you have to be a citizen to apply for the F4 category, if you have citizenship, apply as soon as possible to get the ball rolling. Even though it's going to take forever, essentially, time does fly, and time will come, and it can be a really big benefit to your niece and nephew, especially if you have that. This becomes a really important matter in those kind of cases. And Anya, go ahead, go ahead.
Yeah, and one more thing is that a lot of people, they think, oh, it's gonna take forever. I don't want to file. you know, you never know what's going to happen. Like, look what happened with Ukraine, for example. No one knew that this war will happen in 21st century, right? And you never know how else you can use this petition later. The main point of today's video is that it may not necessarily be the option F4 for you right now, but again, having that somewhere as a plan B may help you later on.
Exactly. And so, but we see these delays not only in this F4 sibling category, but also all the other child of green card holder categories, even citizens. So F1, adult child, that's single of a citizen. F2B, adult child of a green card holder is single. And F3, adult child of a U.S. citizen that's married. They're barely moving. So from, let's say, the visa bulletin, the line that existed in March till now we're July, I'm recording this, 4 months have gone on, but this line has only moved forward 2 to 4 weeks worth of time. So there's massive delays there, and it's very frustrating because some people they're almost there, and it's just not moving forward, and it causes a lot of disruption, including age outs for family members. The worst of this is the F2A category, which we're really happy because for many years it was current. F2A being a spouse of a green card holder and minor children of a green card holder. Then out of nowhere, a huge retrogression happened, which means the backlog of a line emerged that went back now to cases filed in 2020, almost 2.5 years back, September 2020. So it's a big mess, Anya. What have you been seeing on the ground with these kind of cases?
Well, yeah, it's very frustrating, specifically with the F2A category, because as John, you mentioned that for like 3 or 4 years it's been current, and now it's not current anymore. There are two groups of dates. Like, you still can file, you know, if you are in the United States under the adjustment of status process, right? But if you're overseas, you know, you need to wait for your priority date to become current. Okay.
Yeah.
And what you can do for this kind of cases specifically, if your petitioner naturalizes, right, you can jump out of the visa bulletin line and you go to the immigrant immediate relatives category. They don't have a visa line there. So if your spouse, for example, is close to file for naturalization, please file for naturalization as soon as possible. Please contact with an attorney before you do that, because not all people can file for naturalization, even though you think you can, but there are some like few issues might be with that. So it's not always beneficial, but generally, again, filing for naturalization can help this case moving further and faster. Also, another thing that we see often, if, for example, you got your green card through a employment-based category, and now you're a green card holder and you need to bring your family to the United States, okay? At least two options we're seeing here, right? First option is filing I-130 under F2A category, green card holder filing for spouses and minor children, okay? As we mentioned, there is a backlog there, at least like 2.5, 3 years right now, okay? Second option is that you can always file I-240 follow to join. Okay, and the good thing about I-240 is that I-240 uses the priority date of the primary applicant, okay, the earlier priority date. While if you file I-130 for your spouse right now, they will use the current date when the I-130 was filed, and this will probably take longer. Again, we don't know what's going to happen. Maybe this category will become current again next month. Maybe in April, in September, it's going to happen. In October, when the new fiscal year will start. Again, we don't know this, but it's something. It's something to be mindful and something to think about it when you making this very important decision for your family.
Mm-hmm. Now, I do want to say, naturalizing is a big deal, and it will speed up if you're married, for example. The F2A case will become a immediate relative case, which means you don't have this line. But you got to be careful. If you have children, minor children, once you become a citizen, those children will fall out of the F2A petition. You have to separately petition I-130s for that. So that happens. And if you're using the Child Status Protection Act, your kids are now over 21 while the case is pending, and you naturalize, they lose out on their ability to stay their age under 21. So it's a lot of nuances that can happen. Is you got to be careful. So if you are married and you do naturalization, it's all good. But if you have minor children that were part of that F2A I-130 petition, you're a green card holder, you filed for your spouse and kids, you got to be careful on naturalizing to time it right. Or if you do naturalize, file separate I-130s and request expedites for the children so the case catches up with the mom's case, for example, in that kind of, or father's case, whichever it is. But there are a lot of nuances here, and that's why we say it's best to just schedule a private consultation to be prepared for it ahead of time, instead of trying to play catch up, fix things after mistakes happen. And we get these calls all the time where people make these mistakes and it becomes a big problem in their lives and leads to family separation.
Right. So answering the question, is it a still good option, F2A in 2023? Yes, it's still a good option, unless, again, you don't have any other options, like we just talked about, if your petitioner can naturalize and you can jump out of the visibility and you'll forget about this thing. Yeah.
Yeah, and we'll talk about this. Like, there's employment based. We had one couple where it was going to take too long, but they could have done an EB1A extraordinary ability, which is much faster. So they went down that route. It's a harder case to do technically, but the client had the background for it to say we're one of the best at what we do. To not even do a marriage case. They're married. They could have done the marriage route, but they went the employment based route based on their high skills. So that's when it's possible. But
yeah, we're gonna talk about employment based cases in a second.
Yeah, but before we get to that, is the diversity visa, the green card lottery. This is something that a lot of people across the world could play with and apply. And we get people get these approved all the time. Although it's a small percentage, we see it happen. It's a game changer in people's lives and their families. Can you talk about how that program operates and some crazy things we saw this year in the green card lottery program?
It got so much better after the pandemic ended. So more people now get in diversity visas rather than if we talking about like 2020 or 2021. Okay, so hopefully this year they will be able to use all the numbers available. It's 55,000 numbers available for diversity visa winners. Okay, something interesting we saw this year for the first time probably ever is that there are really high numbers in diversity visa selection. So we saw one number that was more than 100,000. This is like crazy. We have not seen it before. What is this about? Well, it does not necessarily mean that this person who got the 100,000 number will be eligible for, will get the visa, because the number is really, really high. But it shows that more and more people apply and more people get selected. And out of the selections, not all people actually apply for diversity visas. Again,
Mm-hmm.
So even if you applied for diversity visa, you got super high number, don't get discouraged yet. It's not clear, right, if you will be able to get you in even with the high number, or you will not be able to do that at all. Okay, so currently I think it's like around 60,000, depending on the area, all right. But again, there's still hope. We still have like few more months until the end of this fiscal year, so we're gonna see how it's gonna go. Is this a valid option again for 2023? Yes, it's a better option than it was like a few years ago. So if you want to apply, consider applying.
And just be mindful, if you're going to do what's called adjustment of status, you're already in the United States and you want to get the green card lottery in the U.S., you have to have a clean immigration history. If you have violations and stuff like that, you're not allowed to do adjustment of status, and you do consular processing. We had a guy who unfortunately dropped out of school and had some issues, and we couldn't get the green card in the United States. But he went back to his home country, did the embassy interview, was approved immediately, and came back once the interview happened. So it's possible to do that, but just be careful, because a lot of people file for green cards on their own when they win the green card lottery, and you don't want to wait to the interview with USCIS to find out you made a mistake. Prep for it ahead of time, because you still get the green card if you had a violation, depending on what the violation is. But if you did in the U.S., you can still go and get the embassy, but you just got to do it, because diversity visa green card lottery has a deadline. You got to get the case done before the end of September. If you don't reach that deadline, then you're out of luck. And if you choose adjustment of status, they want to switch it up, go to the embassy, there might be a good chance that you're never going to get to the embassy in time to be able to finish the case off before the deadline. So very important to watch. Now we're going to move to like the work-based immigration options. There's non-immigrant, there's immigrant visas. Non-immigrants are those where a person is here on a temporary basis to work, and then the immigrants are the green card version of it. We're going to talk about the H-1B. I'm talking about the L-1 very briefly as well. But Anya, the H-1B visa, this is a popular one that's been popular, famous. It's controversial even. This year was crazy how it went down. They're probably going to have to revamp the whole system. Can you talk about why it was such a mess this year with regard to H-1B lottery?
Yes, this year we've seen like numbers that we have never seen before. So this year, the number of eligible registration reached almost like 758,000 eligible registration. And don't forget that there are only 85 visas available. Okay.
Mm-hmm.
And last year, for example, there were only 475,000 eligible registrations. Okay. So it's almost double. Okay.
Yeah.
And the bad thing is that the percentage of those who are selected drop down significantly. Okay, if we, in previous years we saw maybe like 25% registration selection number, now it's less than 10%. So the chances of someone, if you applied this year, of getting selected during the first step, which is like basically H-1B lottery, it's very, very low this year. And we don't even, like, if nothing changes, if USCIS doesn't change the system, because there were a lot of registrations for people who applied through different employers. Generally, it's allowed, but again, some people applied like through 10 or 8 employers, and some people applied through one employer. And of course, those who applied through one employer, they had so much less chances of getting selected. So we don't know if USCIS will gonna do anything about that. But if they don't gonna do, we will probably not offer this option to our clients anymore, because really it's very, very low percentage that it's gonna work. And again, to our clients, what we tell them, what is the alternative for that? Maybe someone would qualify for O1 visa, right? Maybe someone will qualify for national interest waiver. Maybe someone even will qualify outright for EB1A green card extraordinary ability. Okay, so is this a valid option in 2023 H-1B? I would say no. This is probably not gonna work
this year. One thing they did is a couple years back is they made the registration only $10, which entices more people to just throw the hat in the ring to give it a shot. What they're probably going to have to do is increase the fee so that it's high enough where people won't just give it a shot and test it out, and amongst other things. Now, when we get one of these cases, some attorneys have a policy of waiting to see if the case is approved, then doing the research and even see if the case is justified, if the person has the background, if the company has the paperwork for it. But we do an initial review of it first, and essentially do almost half the case, at least, if not more, ahead of time, because we don't want to allow it and realize, oops, we couldn't do it. I mean, we didn't have, it was never going to work in the first place. We want to be really prepared. So once approved, we can submit the case and get the ball rolling as soon as possible without delay. So there's different ways people do it, but H-1B this year was such a mess, and it really hurt a lot of businesses who are relying on this because these massive amounts of numbers. We'll see what's going to change going to happen. But speaking of massive amounts of numbers, the employee-based preference categories, these are people who are in line for a green card for based on work. There's 5 different preference categories: EB1, employee-based 1 through 5, and each one of those kind of has a subcategory. EB1 has 3 subcategories, EB2 has 3 subcategories. These are seeing backlog, especially the EB2 and the EB3 category. Anya, could you talk about what's going on there and these estimated numbers? People are given that it takes 100 years or something to get these cases done. It's crazy numbers.
Yeah, there are some sources suggest that, for example, if you're Indian national and you are just about to file EB2 or EB3 case, right, starting with prevailing wage determination, it can take you like hundreds and hundreds of years to actually get the green card. It's math, okay? So not clear if it's gonna happen this way or not. But one thing is clear is that if you look at the visa bulletin, and these numbers actually does not reflect that you will have to wait this amount of time. Okay, so for example, now EB2 for rest of world is at February something 2022. Okay, so you can think about it like, okay, I would probably need to wait for 6 months. But actually, it's not maybe the case necessarily, because again, visa bulletin does not allow for the backlog that's there pending. It doesn't allow for the prevailing wage determination backlog. It doesn't allow for labor certification backlog. It doesn't allow for the backlog of people who are currently have about to file I-140 or already filed I-140, waiting for the I-140 to get approved. So these numbers are crazy, crazy numbers. And again, if you're thinking about like filing for EB2, EB3, and at the same time, maybe you're qualify for EB2 national interest waiver, right? Because you can get premium processed, right? And you can get the case out like faster, right? You don't have to wait for prevailing wage. You don't have to wait for labor certification. That's going to take like time right now. So maybe you would want to consider doing that. So answering the question, is EB2, EB3 an option? In 2023, I would say yes and no. If you have other options, try to pursue them.
Mm-hmm. Now, so that's the thing. These options are really backed up, and we had cases where people got their green card in the United States and want to bring their family over. They got to use from I-24, and then retrogression happens, so they're going to be separated from their family members until the visa bulletin becomes current for their date again. So it's a very it's frustrating time. But you just got to certain things you got to file to get it locked in. So, for example, kids' ages get locked in, but it's something you're mindful of. And we're seeing this also in the EB4 category for SIJS and Afghan national religious workers. We're seeing this in EB5 investor visa options. These are, if you have to do it, you got to do it, but it makes it harder to recommend these per se. And even for valuable cases and stuff, there's certain delays that come with the process. So if you can, as Anya said, look into employment-based 1A, extraordinary ability, maybe the NIW, which is part of the EB2, which has its own delays, and naturalizing when you need to, using an O1 or H, or maybe an L visa, which I skipped talking about. But the L visa seeing as difficulties and approvals, not just delays, but an approval from USCIS. So these are things to do. If you're a citizen watching this, contact Congress. Let them know. I mean, the things have to operate. People have to come and go. Businesses need this. Families need this. We got to streamline the system to be able to get the loved ones together and top employees here in the United States to keep the machine going.
Yes, exactly. So just to recap our today's video, think about what other options you may potentially qualify for, right? As I mentioned, EB2 national interest waiver self-sponsored petition is a very good petition. Again, it still has a little bit of backlog, but if you file like right now, you might not need to wait for like 6 or 7 years, like some other people would need to wait. For example, if they file with an employer just regular EB2 or EB3 case. Okay, so think about if you can qualify for EB1 extraordinary ability, for example, like all these kind of self-sponsored petitions. Again, if you're thinking about H1B, think if you can do O1 instead, because it doesn't have cap, and there are more chances that you're going to get that rather than you're going to get picked in H1B lottery.
Yeah, unfortunately, yeah.
Exactly. Again, if you are a green card holder and you're eligible to file for naturalization and you want to file for your family, think about filing for naturalization. Disclosure, we gave disclosure earlier about that, but generally it's getting harder and harder to immigrate to the United States because more and more people want to live in this country. And actually, it's a good thing. It's not a bad thing, right? But at the same time, these visa numbers from 1990s, right? These visa caps that were created, they don't help. And we hope that something will change in the future. But until something changes, you need to consider, again, other alternative options if you want to immigrate to the United States faster.
For sure. Thank you, Annie, so much. If you want to contact us, just see our emails below. You're anna@jqklaw.com. It's the best way to reach you and schedule a consultation and talk about individual case. That's the best way to do it. Thank you so much, and we'll be back in soon with some more new information. Bye-bye.
Thank you so much, everyone, for watching. Please leave your likes, comments below, and we will see you in the next video.